Okay, so I'm going to start now. But as I say, for any of you who have just joined, this is a webinar that's being recorded, so there will be a link afterwards. But welcome to this webinar on working with litigants in person, top tips for family lawyers. My name's Gemma Kemp, and I'm a senior associate at Pennington's Manchers Cooper. I thought it might be a useful topic to touch on because I think, as we know, we are meeting more and more litigants in person in our day-to-day workings. And statistically, the latest statistics show that it's only approximately 20% of family law cases in which both parties have legal representation. There are obviously some cases where one of the parties is represented or they have ad hoc representation or advice, but we are going to be coming across litigants in person more and more frequently. And working with litigants in person can be challenging, particularly given the emotional and sensitive nature of the work that we are doing. Usually it's involving very personal matters to them. And it is a very tricky time for the family unit usually. And we as family lawyers have got a duty to treat litigants in person with respect, even when that's not being reciprocated our way. And today I'm going to look at how we can manage some of the trickier situations and things to bear in mind when we are working with litigants in person. So what potential issues may arise when we're working with litigants in person? These are personal experiences, and I'm sure some that are shared by some of you. But being bombarded with emails and phone calls, I think my record was 37 emails in a day. And there may be records that have broken that, but that was quite a busy day. On the other end of the spectrum, lack of engagement where you get no information at all, no communication whatsoever. Disclosure documents from an LIP, sometimes interesting. I've had bags of documents dumped at the front desk, and these days, usually by email, again in no particular order, can be quite tricky to sift through. At the worst end, I think, is the aggression, threats, and intimidation. That's never a nice one, and it's important to get some support if that is happening to you. And also the unnecessary and vexatious court applications. Sometimes that's a factor. And also the approach that I think is important for us as family lawyers to try and overcome and to encourage disuse of is the battle approach to communications. When people are in divorce scenarios or where their family unit is breaking down, they often enter into a kind of a battle mentality. And that's not helpful. And there are things that we can do to try and move away from that, as I'll go through in this webinar. I do, however, have some positive stories about my experiences with litigants in person. And some of those have included receiving thank you cards from a litigant in person to thank me for my help in kind of coming to a resolution for the family as a whole. I have had positive feedback from judges where I have represented my client and there's been a litigant in person, and it's always important to remember that in the court scenario in particular, it can be even more frightening for a litigant in person. So there are some positive stories, and I have had some thanks, and hopefully you have too. And some do take more of a sort of business approach, I would say, but it all obviously depends whereabouts in the emotional process they are. And again, that's something to bear in mind, this roller coaster that they are on. It is not a binary process, and there are ups and downs, and there are good days and bad days, and that's for our client as well as litigants in person. There is some research about litigants in person, and the Ministry of Justice produced a paper. It was back in 2014, so it is out of date, and I can't see that there has been any updates, but even then, there were some interesting stats that came from that. So most litigants in person were in person due to affordability. It wasn't through choice. And that's interesting, I think, when we come to the psychology. Some of these people want to have representation, not all of them, but some of them do want to have representation, and they just can't afford to pay for it. And as I say, only 25% of LIPs were in person due to choice. Around half had received legal advice at some point during their case or representation at court. And almost all LIPs had difficulties with court procedures and the legal issues. And again, if you put yourself in that scenario where you're in a process where, to them, I would think that they think their family is at stake, or there are important issues at stake, money, children, and they don't understand the process, and it's not being explained to them from their own lawyer, that can be, I would imagine, quite terrifying. Around half of the LIPs were personally vulnerable in some way, which made understanding the processes even more difficult. And what I found interesting was that LIPs were no more likely to bring unmeritorious applications than represented parties. And I don't know if that says more about us as lawyers making these applications, but there is no difference seemingly, or very little difference, as to whether unmeritorious applications are being made by unrepresented parties. So our duties as lawyers, we've got a number imposed on us: duties, responsibilities, obligations, whatever label you'd like to put on them. The SRA Code of Conduct puts some fairly hefty and important duties on us. The Family Law Protocol obviously applies where appropriate, and the Resolution Code of Practice for those of us who are members. And even if you're not a member, the Code of Conduct can be a useful starting point, particularly when dealing with litigants in person. And I'd encourage you to read the Code of Conduct, even if you're not a member. So the important ones there are a number, but the important ones that I would like to highlight is the SRA Code of Conduct imposes on us a duty to maintain trust and act fairly. That means not allowing your personal views, which may be influenced by others, including clients, to affect our professional relationships, and that includes with litigants in person. We shouldn't be abusing our position by taking unfair advantage of others, and we should be treating others with fairness and respect, and not harass or intimidate or pester others. And again, that includes litigants in person. I think it's probably usually the other way, where we're being seemingly harassed by the litigants in person sometimes, but they don't have the same duty. There's also an obligation to ensure that the initial letter to the litigant in person briefly addresses the issues that are relevant and avoids unnecessary arguments and one-sided assertions. Sometimes I think our clients would like us to be a post box, a voice box for them, and simply send out a letter with lots of allegations. And I know we will, that's not what we do. But that said, in practice, I think we probably have all seen it. And that first letter is crucial when it's a litigant in person, because sometimes that's the first communication they've ever received from a lawyer. Sometimes that's the first heads up they've got that their relationship is in trouble, or that there are issues with the arrangements for their children. So that first letter, it's worth spending some time on it. And I know most of us probably have a standard template letter, but it is worthwhile thinking about whether or not that does need to be tweaked and adapted. The tone needs to be monitored. Obviously, get it checked by client first, because I always say to my clients, you're best placed to gauge how this is going to be received. But also have a think about when you're sending that letter, and what might be going on. Our clients might be able to give us some insight as to, is the litigant in person on holiday? If so, do we really want to send a letter whilst they're on holiday? The other thing to flag is where we're sending that letter. Are we sending it to the litigants in person's work email address? If so, a word of caution, because I think Resolution get a number of complaints about emails being sent to work email addresses without consent. So a lot to think about with that first letter, and it is, as I say, worth taking the time to do that. We recommend that the litigant in person seeks independent legal advice. Something that, and I do that as part of my standard letter, but one thing that was kind of brought to my attention that I think is worth mentioning is be sensitive to the fact that actually that suggestion, or that recommendation that someone takes independent legal advice, could be construed as aggressive, especially if they thought that matters were agreed already. Why would I need to take legal advice? We've already agreed matters. Take some time to explain why it would be helpful for them to take the independent legal advice from a specialist family solicitor, and explain that the recommendation is good practice. Because again, how that is received, we need to take out any perceived hostility, even if it's not intended. And also, Resolution, very vocal on reducing and managing conflict and confrontation by not using inflammatory language. That's the Resolution Code of Practice, and that is also crucial. And it's important to remember that we're dealing with people. And this is probably why some of us came into the area of family law, is because we like people, we find them interesting. And it doesn't, it makes every day different when you're dealing with all sorts of different people. But these are going to be people, as I say, going through very difficult times. And as it is worthwhile just reflecting on what might be going on with them. And again, this is clients as well as litigants in person, but with our clients, we spend some time with them. We find out where they are in the grief process. We don't necessarily get that from the litigant in person because we won't necessarily have spoken to them. And they're not necessarily going to be in the same place. This, because our client is at one stage of the process, does not automatically mean that the other person is as well. Try and get some of that information from the client, I would suggest. Try and find out what kind of behaviours, where the litigant in person is, because again, the approach will help, I think, in taking out any perceived hostility and kind of dampening down any flames that may arise. And psychology plays a big part in the work that we do. We need to understand what is going on with people, and we work with all sorts of different people. No two people are the same. And they're going to be going through one of the most stressful, uncertain, and distressing periods in their lives. That should also be borne in mind when we're listening to our own clients. They say they'll have their own spin on what's been going on and why. And usually, I think in that first meeting, often they're trying to get us on side. They want our sympathy. They want us to, empathize with them, sympathize with them, tell them they're right. And we need to be a bit careful about that, whilst also being reassuring and letting the client know that we are there to support them. I often say, not necessarily out loud, this is normally really between my children when I'm mediating them, but I often say there's more than one version of the truth. There's person A's version of the truth, person B's version of the truth, and then the actual truth. And I think it is important to keep that perspective. And as I say, it's also important for our client to believe that we are listening to them and that we believe them. So it's not a case of saying, well, yes, but let's see what he says or she says. But do remember that there is another side to the story. Don't become a postbox is essentially what I'm saying. And as I say, we're often able to gauge our own clients' perspective and where they are in the process. After having that initial kind of explanation from the client about what's going on at home, where the behaviours are, I often ask whether they think it would be helpful for me to have a phone call with the litigant in person. And I'm only suggesting this if you're comfortable in doing so, and it's not always appropriate in all circumstances. But certainly in my experience, when you put a voice, a face, if it's a Zoom meeting, when you kind of introduce yourself in that way and step away from the letter writing, the emails, it can become a much more positive experience I think for me as a practitioner, but also from the litigant in person. And those positive experiences that I've had, where I've had thanks and praise, have been where it's been a personal interaction. You're obviously going to need to write them, but just be careful because the written word can be misconstrued, as we well know probably from personal experience. So it can be a positive experience to have a personal introduction. I will always find out from my client if they're happy for me to do that and explain the likely advantages of me doing so. And I think to date I've only had one client say I'd rather you didn't. And I think that's simply because my client, I think, was probably not in the strongest position, and didn't want me to listen to all of the terrible things he'd been doing. But generally, it can be a helpful introduction and a helpful starting point. As I say, psychology does play a role in the work that we do. And I looked at a study by Carl Jung, which essentially is this. Carl Jung has done a lot of psychological work in psychology, but this is kind of reduced down into something that I think is helpful to bear in mind. And he's known for his theory of personality. And you can do the personality test online. I did it yesterday and I am sunshine yellow. But again, when dealing with litigants in person, as well as our own clients, as well as our children, as well as anyone else we encounter, but in particular today, for today's purposes, litigants in person, it's worthwhile trying to find out which colour they are most likely to be. And the theory is that, we're not ever one colour. We tend to be a mix, but there's one colour that comes out stronger in our personality. And I'm going to set out some kind of top tips and communication tips for each type of personality, which you might find useful. You might never know what colour the litigant in person is, but generally, if it's an ongoing matter, I think you'll get the gist. So the four colours are cool blue. They tend to be cautious, precise, deliberate, questioning, and formal. The fiery reds are competitive, demanding, determined, strong-willed, and purposeful. Sunshine yellows are sociable, dynamic, demonstrative, enthusiastic, and persuasive. And earth green are caring, encouraging, sharing, patient, and relaxed. So if you've got a fiery red litigant in person, the communication tips are set out here. So get to the point, make the goal clear, set out the why, what, and how, provide details, and be action orientated. Follow an agenda, take time to listen, use a moderate tone, don't move too slowly, don't leave things until the last minute, don't be vague, and don't talk over them. Now, I appreciate that not all of that will apply in the context of a written letter, but as I say, it might be that you have direct communications. But even if you don't, even if it is all in writing, some of those will apply. And kind of getting, so I would suggest if you're writing a letter and you've got a fiery red person on the other side, you can get to the point. That doesn't need to be aggressive. You can get to the point being constructive. So it's also always careful, always be cautious with your language and I'll come to the language part in a second. But these are sort of the Carl Jung's top tips for dealing with fiery red personalities. So the sunshine yellows, this is all about positivity generally. And there's a time and a place for that, because sometimes we do have to deliver news that they don't necessarily think is positive. But again, the way that we package that up can be constructive. So ask questions. And again, if you're engaging with a litigant in person, I think you can do that, particularly if it's an in-person or on the phone conversation. Even if it's in writing, to make sure you can ask, have I understood all of this, in terms of, going forwards to next steps, because this should be our role is to kind of, find a solution for the family as a whole, which does mean cooperation. So be positive. As I say, that might seem like it's not best placed here, but I think it can be, depending on where you are and what you're talking about. Ask about them. And this is where I had that direct communication with a litigant in person who was a relatively new mum. And we had a conversation about trying to agree the terms of the wording of an order. And I asked her about her little one, and about how she was getting on. Didn't get personal. There was obviously no legal advice. It was just, how are things going? And I think that definitely helped us to have that more collaborative conversation when we were talking about agreeing the terms of the order. Involve and engage them. And again, giving that example, I got her on board. Let's talk about what we want in the order. There were some points that actually we didn't agree on, but that was okay. We agreed it was okay to disagree, and we popped that off to the judge for some tweaking, for the judge to decide the outcome of that, and that was absolutely fine. Do communicate and don't withhold information. Sometimes I think litigants in person, their family life and their divorce and the separation and the arrangements for the children can become all-consuming for them. It is their primary focus, and sometimes they forget that we have other clients, and we have other responsibilities, and we have our own lives outside of our jobs. And so sometimes we do get emails outside of hours that we don't need to be responding to then and there. But I would be more cautious with the litigant in person in acknowledging the email. Thank you very much. I'll take instructions. keep them updated really as much as you would with your own client. Don't withhold information. I mean, obviously we've got duties to our clients, so that is subject to the duty of confidentiality that we have to our client. But some litigants in person, the more distrustful ones, I suppose, sometimes think that we are not, we are coming at this with an agenda and we're not giving them all of the information because it doesn't suit our client. And again, depending on what you're talking about, it's not appropriate to provide all of the information, and nor are we duty bound to do so. But I would say that applies to things like communications with third parties or the court. Word of caution with the court: it's okay to keep them in the loop with communications that you're having with the court, but do not copy them in with the judge's email address. I tend to do a redacted email, forward it onto the litigant in person, take out the judge's email address and say, this is what I've sent. Offer reassurance so far as you are able to and is appropriate. You can't promise anything, obviously, but you can try and reassure them that this is, you are trying to work together for the best interests of the family. But you have got a job, and that's to act in your client's best interest, but that does mean working together as far as you can. Don't over-dominate. I think some lawyers may be guilty of this, and I have seen it, where I have taken on a person who has been acting in person and I've taken over the case. And I have seen correspondence that has been trying to, I would say, dominate. And actually sometimes a little bit more than that, but better just keep in mind, check your language, check your tone on your communications. Don't get bogged down with the details. Now, with some of these colors, they like the detail, they want the detail. The blues definitely want the details. If you're dealing with a sunshine yellow, I mean, again, I would say provide as much detail as you think is appropriate. And in some circumstances, you're going to have to go to all the details, because that's the nature of, unfortunately, when we're dealing with things like orders, the detail is the important part. But I think it's probably a case of provide the information that's required, and don't go too deep into it, or at least provide a little summary at the end. And don't leave them out of the picture. Again, that goes back to keeping communication, keeping them updated, even if that's just a thanks for your email. It does help to keep things on an even path. So those are the sunshine yellows. Next up is the earth greens. So the earth greens explain why something needs to be done. I think we would probably do that when we're dealing with a litigant in person, quite honestly, in any colour. Give advance notice. So sometimes that's outside of our control if we get a court hearing last minute, but again, keep them updated really. Allow for feedback. Again, that can be helpful when it's coming to things like orders. And engage them in collaborative discussions. So I tend to find, not necessarily litigants in person, but when we have roundtable meetings, it tends to be sort of the earth greens who are more open to roundtable meetings than other colours. Be respectful, check the tone of voice. I think we would do that anyway, but be more cautious of it when you're dealing with a green. Be attentive and genuine. Don't tell them what to do and how to do it. Again, we might need to do that with a litigant in person, but how we package that up is a big part of it. Don't micromanage. Don't be aggressive. Again, I'm not sure we would ever intentionally be aggressive, but check the tone, check the language, and don't rush them into decisions. And when I thought about that one, I think that's the please respond within 14 days, or and the consequences. I think there's probably a nice way of saying that, depending on the circumstances. Cool blues. These are the cautious, precise, deliberate, questioning, and formal personality types. They want clarity. These are the people who like the lists and the agenda. They like to reflect. So bear that in mind again when giving kind of realistic timeframes for things. Provide detail in writing. So these are the ones who are the opposite of the sunshine yellow. They like the detail. Remain focused. I think we probably would, and again, I guess that comes down to trying not to inject our clients' words into correspondence. Provide recaps. I mean, that's probably a case for when you're in court, and there's a litigant in person. Support the point with examples. And again, I think in terms of letter writing, it can be easy to fall into sometimes the language that we understand. So the next hearing will be an FDR. Explain what that is. Explain not just what it stands for, but what it is. We can give guidance to litigants in person. We can give them some general information. We obviously can't give them advice, but again, often offering up that information can take away the fear for them, and it can really help to get to start on an even tone. Provide all the relevant information. We're duty bound to do so. Don't put them on the spot. I think that's fine. Take some time, think about it, come back to me when you've gathered your thoughts. Don't send meaningless emails. Again, I think that's probably more the other way around, but make sure your email's got a point. Don't waste time. I think sometimes that can play out in letters. Do we really need 7-page letters? Probably not. Can we take some of that out? And don't waffle applies to the same. I think it's an art and it's a skill, and it takes time from when you're newly qualified to getting the right kind of information in that initial letter, or any letter actually. And the next thing to bear in mind is the family solutions group. Now, this comes off the back of what I've just talked about in relation to those personality types, because irrespective of what kind of personality you're dealing with, and as I say, sometimes you might know, sometimes you might not, but you probably will get a feel as things move on. The likelihood is they are all going to be feeling similar things at similar points. So they might be feeling that they're at a disadvantage that they haven't got a lawyer, particularly if it's not through choice. They're likely to be feeling distressed, angry, confused, particularly if they're unfamiliar with the law. And those statistics that we were talked about previously, pretty much all of them felt confused by the process, and by the legal jargon. So again, it can't be easy feeling confused and all of these emotions, thinking that what's at risk is your family, finances, children, and whilst you're also going through a grieving process. And they're likely also to be feeling stressed and anxious when they receive correspondence from us. And again, I reiterate, and I know I've said it a million times, but that first communication is crucial. The other thing to bear in mind is, who is our client? Sometimes the litigant in person is the financially weaker party who can't afford the legal advice. Other times it's the financially stronger party, and the litigant and they just don't want to spend money on lawyers, or they think they can do the job better than lawyers, or sometimes they are lawyers. In my experience, they are the interesting litigants in person, particularly if they work in corporate or litigation where they're used to hard-nosed negotiations, and it doesn't quite work like that. I think we are a very different species as family lawyers. We're not just dealing with the hard, cold facts and numbers. We are dealing with, as I say, people and their lives, and that has a huge impact. The other thing I say, just before I turn to this family solutions group, is be alive to domestic abuse. There are various toolkits online. Resolution has a domestic abuse toolkit that can be useful, but sometimes the perpetrator of the domestic abuse is not the litigant in person. They are the person who's instructed the solicitor, and they can be using the process to continue the abuse. And again, that goes back to be careful and mindful of your communications with the litigant in person. Who are you acting for? And I've certainly had personal experience here as well, where the litigant in person was the financially weaker party, but it was a tricky situation. I think she'd had a tricky time in the marriage, and that took some careful crafting in terms of my engagement with my client and the litigant in person. Ultimately, as I say, the duty is to the client, but equally it's important to remember that they are people that we are dealing with on the other side as well. Right, so the Family Solutions Group, you may have come across them. They have run a project called Language Matters, and they have run quite a large campaign about stripping down the legalese and the language that we as solicitors use in our day-to-day workings. Over time, you'll be aware that we've moved away from concepts such as parental rights to parental responsibilities and custody, to a more family-focused wording. And it doesn't end there. The idea is to take away combative language. So it's not about the battle, it's not about the fight. It is about solution-focused words, solution-focused approach to the work that we undertake. So it's worth bearing in mind what they call the 5 Ps. So speak in plain English, avoid legal jargon. If you have to use a legal word, because it makes it a lot easier, it reduces everything down, again, explain what that word means and explain not just, again, what it stands for, the initials stand for, but what the actual meaning behind it is. I think, we have a lot of acronyms in family law, and we can forget sometimes that we're just so used to using them. We just assume that it's become everybody else's language as well. And of course it hasn't. So there are glossaries online with acronyms. And it might be worth, if you haven't already got one, putting one together. But equally, I think it is worthwhile, even with a glossary, I think it is worthwhile setting out in your communications an explanation. Use the plain English wherever possible, but if you can't, explain what you mean. Personal. So this is using family names rather than their legal titles. So Sarah rather than the applicant, or even your client. So there's a real move away from trying to use our client, your client, and making it more about using their first names, personal names, and the children's names as well, rather than the child or children of the family. In letters, in correspondence, use the children's names. Proportionality. So use language which is proportionate to the issues being considered. No hyperboles and no unnecessary adjectives. Again, we've probably all come across that correspondence where there's a lot of strong views being voiced by the writer about, this is an extremely fair proposal, or words to that effect. Doesn't really have a place. This isn't our view to give. So yeah, keep it proportionate, keep it factual. And if you are going to have to, or you feel that your client needs to see reference to any kind of personal view, it's not our personal view to give. So I would caveat it with, I understand from Sarah that, but again, is it worth it? Is it worthwhile? Perhaps in some circumstances, but just bear it in mind. The next is problem solving. Again, we use constructive solution-focused language. I would urge you to go onto the Family Solutions group, have a look at them online. They have got a lot of examples that they can give. And again, it's moving away from the yours and your side, our side. There's no sides. This should be a collaborative, constructive working solution that is aimed to achieve the best outcome for the entire family. And the 5th P is positive futures. So easier said than done, particularly when we first meet our clients, but don't get stuck on those past recriminations. They want to tell us everything usually about what has gone in the marriage, why the other person is, I say other, I've just told you not to, but for context, why their former spouse, partner, why they are so awful. And they probably do need to be able to air that. I tend to, in my first meeting, go through, who have you got in your team? Have you got, a financial advisor? Have you got some emotional support? Because whilst I'm very happy to sit and listen to what, all of that, what's been going on, more often than not, it's not relevant. Sometimes it is, but I think once you've got through that first meeting, there can be some clients who want to just share all of the information with you, and likewise litigants in person. So especially if you're there, you know, if you've had that personal approach, you've introduced yourself, you've kind of got that connection to a certain extent. There is a line of professional trust there, but often they want to tell you everything as well because they want to have their say. That if they're doing that, it's likely to be spiraling your client's costs. So that needs to be borne in mind, and costs obviously needs to be borne in mind all throughout this when you're engaging with a litigant in person. If it's the lots of emails, lots of phone calls, and I'll come to how best to deal with that in a moment. But kind of try to draw it back to focusing on positive futures, building on those positive futures, especially if there are children, and point out, you know, this is a team effort for the children, in which they can thrive. So move away from the past so far as it's appropriate to do so. Sometimes you'll have to go down that route, but sometimes it's just not going to be relevant to what you're dealing with. And then some practical tips when working with litigants in person. So these are, again, some of the points just to bear in mind. When you've got those excessive communications, and as I say, they can be vast, and it can be phone calls, it can be emails. I've also had people, I've had a litigant in person turn up to the office. It can be a lot. It can be quite overwhelming. The best thing to do, and the advice given through resolution, is to try to remain calm and polite. I think we'd always try and do that in the first instance, but it is tricky the more and more you receive and the more demanding it becomes. It can become incredibly stressful. Explain that you have a responsibility to consider costs for your client and ensure that these remain proportionate. And the costs might be dependent on the instructions that you get from your client. And the instructions might be, please don't respond to unnecessary communications. The instructions that you get are going to dictate the extent to which you are able to respond. And I think setting that out and explaining that, you know, you have other matters that you're dealing with, it can be helpful just to manage expectations. And as I say, I think sometimes the expectations from litigants in person can be just as demanding, if not more so, than the expectations of our own clients. If you do have a conversation with a litigant in person, Zoom, phone call, in person, whatever it might be, and if it is in person, you know, usually that would be, I would think, within the kind of roundtable meeting format. And when I've had a roundtable meeting and it's been a litigant in person, I've asked for them to be accompanied by a third party, usually some family support. When you've had those kind of communications, make sure you've kept a detailed attendance note. I would always recommend that you follow up any agreed points in writing, and just as a, you know, just following up, just so that we make sure that, you know, I confirm that I have understood everything properly. Here's what I understand from our conversation. You might not need to you don't need to give the full attendance note necessarily to the litigant in person, but also your client might say, well, what was said? So we probably always would keep an attendance note, but it's even more crucial when we've got a litigant in person, and do send that follow up just to make sure that, you know, you're protecting yourself as well as anything. If the litigant in person is rude and aggressive, you can say no. You don't have to engage in that to a certain extent. You can explain that unless that stops, you'll not speak to them on the phone if that's how the communications is being received, and insist on all future communication being in writing. I have had to do that. I've certainly been in circumstances where a litigant in person was incredibly rude and hostile to me, but also my PA and my assistant, who, you know, it was quite upsetting for all of us, but particularly more junior members of staff. And it just wasn't acceptable. And I sent an email out explaining that, just keeping it factual and explaining that we wouldn't be engaging on the phone any further unless that stopped. And I asked her to reflect, and then invited her to send her thoughts in an email to me so that I could then take a view as to whether or not it would be helpful for us to have a phone conversation after I'd seen what she'd put in writing. And actually, she sent an apology. Doesn't excuse what had happened, but equally, when you bear in mind where some of these litigants in person are emotionally, it doesn't excuse it, because sometimes it can make it a little easier to understand why they are behaving in the way that they are. Often every behavior is triggered by a need. And again, these people are in very difficult situations sometimes. So, but it is okay to say no. No, I'm not engaging, and you have to protect yourself, and also, the juniors that you're responsible for, the members of staff that you're responsible for. Do review and adhere to the Resolutions Code of Practice, which promotes a constructive approach to family issues for the benefit of the family as a whole. And I use that regularly. That phrase I use quite regularly. We're working together for the benefit of the family as a whole. It does make a difference. Also consider why this person isn't instructing a lawyer. And I've gone through the reasons why they might not be, but why is this particular person not instructing a lawyer? That might give you a clue as to what color they are. It might give you a clue as to where they are emotionally, or where their pressures are. If it's because they can't afford to, are there financial pressures? Probably. As I said before, spend extra time on your first communication. How is that likely to be received? If time permits, ask a colleague to read through it and see how that's been, how that is being construed. Your client will be checking it anyway, but obviously they come at it with potentially their own agenda, and how they want the message to get across. But again, reiterate to your client why we are taking this constructive approach to communications, and really realistically what the impact can be for them in terms of legal costs if one of a better word, blows up. It is important to get that initial communication right. So I've said offer an introductory phone call if you feel comfortable doing so. I'd limit that in time with the litigant in person. Just say, it would be helpful for us to have a 5-10 minute chat, just because you don't want your client's costs to spiral. And the other thing is signposting. So signpost the litigants in person to resources and provide them with general information guides. As I say, we can't provide them with specific legal advice, usually, but we can provide them with some general information. And there's a wealth of information online about not only acting, litigants in person acting for yourself, but also in terms of processes. The government website has got quite a bit of information on it. CAFCAS website. There's some signposting on the next slide, but it is worthwhile. It sort of takes the pressure off you a little bit if you're signposting, because even though they can't get legal advice, they can get support, they can get information, and that can be helpful. And then I would say encourage your client, where appropriate, encourage your client to give the other person time to process matters, particularly if you clock that they are not at the same place in that roller coaster. They might need some time to process matters, to go and see if they can take independent legal advice. It's not always, if you're in a non-molestation situation or occupation order situation, not appropriate. But on the general, probably the day-to-day, it's worthwhile just explaining that can be beneficial to our client. And sometimes our clients are in a rush to get things moving, but it can pay off kind of taking some breathing space. I've said about sending communications to work email addresses. That is a huge source of complaints for resolution. Don't do it unless you've got consent to do so. That consent can either be from the litigant in person themselves, or sometimes if you're substituted service, it would be from the court. Don't set short deadlines. I know clients often want things turned around very quickly. There might be some time pressures. And the one I immediately think of is things where mortgage fixed rate mortgages are coming to an end. But be realistic, and don't set it as a hard deadline. Please, it would be great if you could respond within this time frame. If you envisage any difficulty in doing so, do let me know. The time frame's in there, the client is then happy, hopefully. Don't assume that all your client is telling you is true. I've told that there are various versions of truth, as I said. Don't assume anything. And I think that's true for our client as well as the litigant in person. They're both going to want to have their say. That's probably the hardest part of being a judge most of the time, I would say, probably. They sit and they have to listen to lots of versions of the truth and then kind of find the right one, find the middle. Easier said than done, but try not to take those negative comments personally. And again, litigants in person, sometimes they do go there. Sometimes they do get personal, some pleasant sometimes. Often it says more about them and where they are in their lives in terms of the difficulties rather than actually how they're feeling about you. Sometimes it's a little bit about us. But equally, you know, we have a difficult job here when we're dealing with litigants in person. And it can be easy to lose perspective on, you know, when we're feeling criticized, but just try not to take things too personally. So in terms of the signposting for litigants in person, these are the resources that are probably most relevant. There are others. As I say, the CAFCAS website has a huge amount of information in there. But this is specifically kind of more of a general litigant in person rather than CAFCAS obviously being children. So representing yourself in court, government have got some information on that. The code of practice, as I say, that's downloadable from the Resolution website. And if you are a Resolution member, there is a good practice guide to working with litigants in person. Resolution have a top tip guide for litigants in person. So the litigant in person can go on the Resolution website and there are some tips on there for representing yourself in court. And then on the Courts and Tribunals website, there is a handbook for LIPs. That is a paid for book. There was a downloadable version that I saw, but again, you know, signpost, provide helpful information. It's going to make your life easier, as well as hopefully some reassurance for the LIP. And then looking after yourself. I mean, this applies to, I think, the work that we do generally, but in relation to the work that we're doing with LIPs, just remember that this is likely to be a frightening and uncertain time for them. Consider how they're feeling. It doesn't excuse unacceptable behaviour, but it can help us when we remember that often we're dealing with people at a very stressful time in their life, in the grief process, sometimes dealing with trauma, uncertainty. And we're often dealing with people prior to their recovery stages. So we are really in the heat of it. Emotions are heightened, and usually recovery happens once we've left. As I say, it doesn't excuse some of the behaviours, but it can help us to keep perspective. And when keeping perspective, you know, for us, this is a job. We do it to pay our bills. We do it because we feel passionate about it. We want to help people. I think some of us, if we won the lottery, may not do the job that we are currently doing. But that's what I mean by keeping perspective. This is what we do every day. This is not what litigants in person deal with every day. And as I say, they are really in the midst of it. This is their life. This isn't, I don't want to say just a job, but this isn't a job to them. This is their day to day. So keeping perspective can be helpful. If you find that you are feeling anxious and stressed, and I've certainly been in that position where that name pops up in my inbox and I have a reaction to it, take a breath, seek support from colleagues, your firm, if you're able to, if there's, you know, if there are teams there to support you. I know some firms have wellbeing champions. And if you don't, if you're working on your own, then seek support from friends, without obviously going into the detail, but you can see looking after number one is very important. And seeking support from firm might be, actually, can I have someone else help me with this matter so that I'm not absorbing this all by myself? And I use the word absorbing because that's what we really need to try not to do. Kind of, you can try and imagine some kind of shield between all of the projection that's coming from the litigant in person sometimes and you. Seek support if your firm offers it, and if not, seek support elsewhere, including Law Care. So Law Care have they are basically a wonderful charity who they offer free, confidential and emotional support to anyone who's working in the law. You can contact them by phone. They've got a 24-hour hotline. You can contact them by email, confidentially, anonymously if you need to, but they can be a great source of help when you're feeling overwhelmed, when you're feeling stress. And they have on their website, they have a list of kind of topics, one of which is managing yourself in emotionally challenging interactions. So that one could be very helpful if you've got a particularly difficult litigant in person. And the other thing to bear in mind is Resolution's mentor scheme. If you're a member of Resolution, they offer a one-to-one mentor scheme. I am a member. I am a mentor in that scheme. We are trained to help and assist with exactly this, but also a wealth of other difficult situations that you might be going through. So again, have a look on their website. If you are a member, you can reach out and ask for a mentor to speak to. And even, as I say, even if you're not a member of Resolution, Law Care is there to help you. That is the end of my presentation. I don't know whether we had any questions. Helen, did any come through to you at all?
Hi, Gemma. No, none yet. But if anyone does have something to ask, you can do that in the Q&A box, or you can also raise your hand and we can unmute you to speak. So if you have got a question, maybe just type hello in the Q&A box, just because then we'll know to expect it. Or you can raise your hand and we can unmute you. So we'll just give a minute for
no problem.
questions. Thanks, Gemma. Gemma, but if we received any after the session, would it be okay to forward?
Yeah, of course. Yeah, of course.
Thank you so much. That's been so interesting and really helpful. If anyone, as you leave the webinar, you will be prompted to fill in a feedback form. So if you could do that, that really helps in, oh, there we go. There is a question there for you, Gemma. Costs are a big thing for the client. How best to explain to client needs of dealing with LIP?
Yeah, I mean, it is a tricky one because I think the question really is, the likelihood is that costs are potentially going to be higher because we've got a litigant in person on the other side, and you're having to spend extra time explaining. But that's where I think the signposting can come in useful, and having just some resources and guides, a guide to the court process in finances, or actually on Lexis PSL, for those who have access to it, there is a flowchart of the court process when you're in Children Act proceedings. That will obviously reduce down the amount of time you're spending trying to explain the process to the litigant in person. And although we're not obliged to do that, I do think it makes a huge difference. And it might be worth spending a little bit more money at the beginning, if needed, on cost to explain and set the tone, so that as you go forward, you're not getting those, numerous emails, and you've already set the tone, you've already managed the litigant in person's expectations. It's not binary. There are going to be times when they do probably send more emails than are needed. But I think in terms of managing your clients' expectations, obviously the cost estimates are there and we tend to give brackets on those. But I think it's worthwhile just explaining, look, it's easier, I think, and between the interactions between the two of you, but also my interaction as your solicitor with this person. If I set out quite a bit of information, as I say, by whether that's a standard fact guide that you're sending out, signposting, or you're setting it out in a letter. I get it, it's tricky, and it is probably the biggest concern. But equally, quite honestly, sometimes I get letters from solicitors, not just litigants in person. So it's managing the expectations, I think, all around. But yeah, I think it's being open and honest and saying it can be trickier because I have to go, it's helpful for me to explain this. It's just being upfront about it, I think.
Lovely, thank you. I think there's no more come in. Just give it one more minute, just in case anybody has a last question. But as I was saying, yeah, there will be a survey pop up as you leave the webinar. Please do complete that for us. It really helps with putting together the programme for next year, which we are in the midst of doing. So, but I think that's everything. I can't see anything else coming in. So thank you very much, Gemma.
Thank you all for your time. Thank you for listening.
Have a great afternoon.
Take care. Bye-bye.